Let's get into the Charter of Labor of Fascist Italy. This charter explains not only the working mechanics of the economic system in Fascist Italy, but it also highlights the third position philosophy, intertwined not only with the economics of a nation, but practically in every sphere of it. And for this, we once again pull from Paul Enzig's fine book, The Economic Foundations of Fascism. Article 1. The Italian nation is an organism possessing a purpose, a life, and instruments of action superior to those possessed by the individuals or groups of individuals who compose it. The nation is a moral, political, and economic unity integrally embodied in the fascist state. From the very first article, the philosophy of the fascist state is laid out. The third position thought of the nation being an organism possessing a purpose, a life. Everything else is an instrument or a tool. Government, education, economy are instruments of action to fulfill the purpose and enhance the life of the nation. Article 2. Labor in all its manifestations, whether mental, technical, or manual, is a social duty. It is by virtue of this fact, and by virtue of this fact alone, that labor falls within the purview of the state. When considered from a national point of view, production in its manifold forms constitutes a unity, its many objectives coinciding in being generally definable as the well-being of those who produce and the development of national power. So you are in an actual sense a contributing part in fulfilling the national purpose and enhancing the life of yourself and your fellow citizen. As opposed to today's capitalism, where in general your labor is largely to fulfill basic needs and some material wants while enhancing the wealth of a soulless corporate conglomerate. Article 3. Organization, whether by trades or by syndicates, is unrestricted, but only the syndicate legally recognized by the state and subject to state control is empowered to legally represent the particular division of employers or employees for which it has been formed, to protect the interest of these as against the state or as against other trade organizations, to negotiate collective labor contracts binding upon all those engaged in the branch in question, to levy assessments and to exercise in connection with the branch specified functions of public support. Article 4. The collective labor contract gives concrete expression to the common interest of the various elements of production, capital and labor, by reconciling conflicting interests of employees and subordinating these to the higher interest of production at large. Article 5. The labor court is an organ through which the state acts in settling labor controversies, whether they arise in connection with observances of rules or agreements already made or in connection with new conditions to be fixed for labor. So trade unions and syndicates can organize, but only those who are recognized by the state, meaning they've officially accepted what is placed forth in Article 1, where labor is mediated by the state, can go into labor courts over disagreements with management or even the state itself. Article 6. The trade associations, legally recognized, guarantee equality before the law to the employers and employees alike. They maintain discipline in labor and production and promote measures of efficiency in both. The corporations constitute the unifying organization of the elements of production, capital and labor, and represent the common interest of them all. By virtue of this joint representation, and since the interests of production are interests of the nation, the corporations are recognized by law as organs of the state. So it is all intertwined, and this is why underneath third position philosophy and the economics that come out of third position philosophy, multinational conglomerates, would have a very hard time even existing in a country that practices third position philosophy, but more so, organizations and corporations could never reach a state of power to where they influence or control the state, as you often get in democracies or republics, or any other system that allows corporations to feed on the citizenry in the name of profit. Article 7. The corporate state regards private initiative in the field of production as the most useful and efficient instrument for furthering the interest of the nation. Since private enterprise is a function of import to the nation, its management is responsible to the state for general policies of production. So once again, not crippling private business or even private initiative. That's often a misconception of third position economics. From the fact that the elements of production, labor and capital, are cooperators in a common enterprise, reciprocal rights and duties devolve upon them. The employee, whether laborer, clerk, or skilled worksman, is an active partner in the economic enterprise, the management of which belongs to the employer, who shoulders the responsibility for it. And this is a theme you'll see throughout the articles, stressing it is an active partnership between employer and employee. Article 8. Trade associations of employers are under obligation to increase business, to improve quality of output, and to reduce the costs in every possible way. The organizations representing practitioners of the liberal profession or of the arts and the associations of state employees work together for furthering the interests of science, letters, and the arts, for improving the quality of production, and for realizing the moral ideals of the corporate organization of the state. Article 9. The state intervenes in economic production only in cases where private initiative is lacking or insufficient, or where political interests of the state are involved. Such intervention may take the form of supervision, of promotion, or of direct management. So generally not central planning, but an oversight that is motivated by ethics and an expectation of production, and only stepping in where there is a violation of either. And to what extent they step in depends on the situation. Article 10. In labor controversies involving groups, there can be no recourse to the labor court until the corporation has exhausted itself for adjustment. In controversies involving individuals in connection with applications or interpretations of collective contracts, the trade associations are empowered to offer their mediation for settlements. Jurisdiction in such controversies belong to the ordinary labor courts, supplemented by the referees appointed by the trade association concerned. So if an individual worker has a problem with the employer or a fellow employee, first the trade union tries to deal with it, where the conversation is with the grievant and either with the employer or the employee in question and the trade union reps. If they cannot reach an agreement, then it goes to the local labor court, where the grievant and the accused meet before a local government representative. If that does not work, then it goes up the ladder to a national labor court and they deal with the matter. Article 11. The trade associations are required to regulate by collective contracts labor relations between the employers and the employees whom they represent. The collective contract is made between associations of primary grade under the guidance and with the approval of the central organizations, with the provision that the association of the higher grade may make amendments in cases specified in the constitutions of the associations or by law. All collective labor contracts must, under penalty of nullity, contain specific statements of the rules governing discipline, of trial periods, of the amounts and manner of payment of wages, of schedules of working hours. An obvious intent to try to make terms clear as possible in the contract between the employer and the employee. Article 12. The operation of the syndicates, the mediation of the corporations, and the decisions of the labor court guarantee correspondence between wages and the normal demands of living, the possibilities of production, and the yield from labor. The fixing of wages is withdrawn from any general rule and entrusted to agreements between parties in their collective contracts. Article 13. Losses occasioned by business crises and by variations of exchange must be equitably divided between the elements of production, capital and labor. Statistics relating to conditions of production and labor, to variations of exchange, to changes in standards of living as issued by the various governmental departments by the Central Bureau of Statistics and by the legally recognized trade associations, and as coordinated and elaborated by the Ministry of Corporations, will constitute the criteria for adjusting the interest of the various branches of trade and of harmonizing the interest of various classes with those of other classes vis-a-vis of each other, and of the higher interest of production in general. As it would be written in any contract between the employee and the employer, when business is good, there would surely be a financial benefit for both the employer and the employee. But at the same time, when business had slowed down, both the employer and employee would be subject to a financial penalty. And if things did not improve or got worse, the state would step in to find solutions, be it helping with production problems, price fixing, vouchers to workers, etc. Once again, the employee and the employer are invested in the business together, for better and worse. Article 14. When wages are paid on the basis of piecework and payments are made in intervals greater than 2 weeks, suitable weekly or bi-weekly accountings must be furnished. Night work not compensated in regular periodical shifts must be paid for by some percentage in addition to the regular daily wage. When wages are based on piecework, piece payments must be so fixed that the faithful worker of average productive ability may have a chance to earn a minimum in excess of the basic wage. Once again, it was not free market capitalism that created the minimum wage, night shift differences, paid holidays, overtime pay, etc. We can go on. All of these and much more came through government action, and all were common in fascist ideologies, despite if it was in Europe, South America, the Middle East, it didn't matter. It was in every fascist organization. Every group that adopted a third position philosophy, all were persistent in protecting the worker. Article 15. The employee is entitled to a weekly holiday falling on Sundays. Collective contracts will apply this principle so far as it is compatible with existing laws, and with the technical requirements of the enterprise concerned, and within the same limits, they will aim to respect civil and religious solemnities in accord with local traditions. Working hours must be scrupulously and earnestly observed by employees. Article 16. After a year of uninterrupted service, the employee in enterprises that function the year-round is entitled to an annual vacation with wages, so paid vacation. Article 17. In concerns functioning throughout the year, the employee is entitled, in case of discharge through no fault of his own, to a compensation proportioned to his years of service. Similar compensation is likewise due in the case of death. So unemployment pay, but in the sense of if you worked at a factory and you were laid off for some reason, that was not your own fault. A factor in your unemployment compensation would be how many years you had worked for the company. How many years you had invested in that company would also be a part of what you're being paid while you're on unemployment through them. I do like something about that, like loyalty repaid with sort of financial loyalty. Article 18. Transfers of ownership of concerns offering steady work do not affect labor contracts, and the employees of such concerns retain all their rights and claims against the new proprietors. Likewise, the illness of an employee, not in excess of a specified duration, does not cancel the labor contract. Call to service in the Army, Navy, or in the fascist militias, which were voluntary militia for national safety, does not constitute valid cause for dismissal. So even with new owners, you keep the old deal. Plus, you have sick leave. Also, not a creation of free market capitalism. That must be respected, but up to a realistic point, of course. Article 19. Infractions of discipline on the part of employees and acts disturbing to the normal functioning of a concern are punished, according to the seriousness of the offense, by fine, by suspension, or in grave cases, by immediate discharge without compensation. The cases in which the employer may impose the respective penalties of fine, suspension, or discharge without compensation must be specified. So there's always accountability in this system, or at least they're striving for accountability. Article 20. The employee newly hired is subject to a trial period, during which there is a reciprocal right to cancel the labor contract, the employee in such case being entitled to wages only for the time of actual service. So a probation period gives the employer a fair look at the person to see if he'll be a positive functioning part of the company. Article 21. The collective labor contract extends its benefits and its discipline to home workers as well. Special regulations are to be promulgated by the state to assure proper hygienic conditions for home labor. So I would imagine a stay-at-home mom, amongst other things, would fall subject to that, which is good because, as it states, you reap the benefits as well. Article 22, the state has exclusive power to determine and control the factors governing employment and unemployment, since these are indices of the general conditions of production and labor. So, of course, whenever push comes to shove, the state has its say and not some multinational conglomerate. Article 23, employment bureaus are to be managed by the corporations through commissions having equal representation of employers and employees. Employers are required to practice selection among workers with the right of choice among the various registrants, giving preference, however, to such as are the members of the Fascist Party and of fascist syndicates, and to priority of registration. Yeah, so obviously active fascist members are going to get the first place in line. That goes without saying. And if anyone isn't quite sure how these corporations are set up, linked in the description area of this video will be the video I did on corporatism, which was also taken from this book, The Economic Foundations of Fascism. Article 24. The Trade Association of Workers are required to practice selection among workers with a view to constant improvement in the technical skill and the moral character of the personnel. Fascist tenets at its core, constant improvement and of good character, of keep continuing to build good character is what is looked for, not only in the employee but also in the employer, and in all aspects of the society. Constant improvement in technical skill and the moral character of a person. Soulless capitalism doesn't give a damn about the moral of your character as long as you punch the clock, show up, do your job, contribute to the corporation, then go home. They don't give a shit about the technical skills you could be improving on, or to help or encourage the content of your character. Article 25, the corporations must supervise the observance of the laws governing safety, accident prevention, and sanitation by the individuals subject to the central organization of associations. So follow the safety laws, don't cut corners. Article 26, insurance is another manifestation of the principle of collaboration. Employers and employees must bear proportionate shares of such burdens. The state, working through the corporations and the trade associations, will strive to coordinate and unify as far as is possible the agencies and the system of insurance. Now you see a common theme in all these articles and the larger goal at hand: to strengthen the relationship of the employer and employee, not pit them against each other or oppress one while rewarding the other. Both employer and employee benefit at good times, and both share the struggle during the bad. Both contribute to the insurance and other programs, building the bond of investing together, contributing together, reaping rewards together, and even side by side in struggle if need be. Third position thought does not split the nation over economics and material wants, but rather unifies it by creating an environment of mutual respect and a common purpose. Article 27. The fascist state is working: A. For improvements in accident insurance. B. For improvements and extensions of maternity insurance. C. For insurance against professional diseases and tuberculosis as a step towards general insurance against illness in general. D. For improvements in insurance on involuntary unemployment. E. For the adoption of special forms of endowment insurance for young workers. Article 28. Protection of the interest of employees in legal and administrative problems arising in connection with accidents and other forms of social insurance devolves upon the associations which represent them. Collective labor contracts will provide, where technically possible, for the establishment of mutual funds for insurance against illness. Such funds to consist of contributions from employers and employees, and to be administered by representatives of both classes under the general supervision of the corporations. Article 29. The trade associations have the right and the duty to provide relief for the workers they represent, whether these be members or non-members. Such functions of relief must be exercised directly by committees of the associations themselves, and must not be delegated to other institutions or corporations, save for purposes of a general character which transcend the particular interests of the branch of production concerned. And finally, Article 30. Training and education, especially technical training of workers they represent, whether they be members or non-members, is one of the principal duties of trade associations. The associations must lend their support to the national institutes which deal with the recreation and free time, and to other enterprises of education, investing in building a more educated worker and thus a better man, as shown in the repetitive mentions in the Charter of Labor. When it comes to the duty of trade unions and employers to contribute to educate the worker in the advancement in their respective fields, no student loans, no debt, just a system invested in the people, because the third position is revolutionary in that sense, where it continually seeks to improve people and thus improve the nation as a whole in doing so. And that was the Italian Fascist Charter of Labor, once again found in Paul Inzig's fine book, The Economic Foundations of Fascism. From the Charter, we can see that third position economics is merely a tool or a function used to achieve goals for both the collective and for the individuals, rather than simply just the end upon itself, as is the case with soulless capitalism.